Let me be absolutely direct with you right now. The Supreme Court just dropped a 7-2 emergency ruling that fundamentally alters the balance of power in this country. And if you think that's just legal jargon for lawyers and law professors to argue about in their leather chairs, you are dead wrong. This ruling, this Supreme Court 7-2 emergency ruling, touches your life, your rights, your community, and the future of every major policy fight in America. And I am furious that most people woke up this morning without the faintest idea that the ground beneath their feet just shifted. That's not an accident. That's a failure. A failure of the media, a failure of our institutions to communicate honestly with the people they're supposed to serve, and a failure of a political culture so consumed by noise that it can't recognize a genuine constitutional earthquake when one happens. So right here, right now, on July 20th, 2026, we are going to break this down in language that every single American deserves to hear. Not softened, not sanitized, not filtered through political spin. The truth. Because what the Supreme Court just did in this 7-2 decision isn't just a legal story. It is a power story. And in America, power stories are always your story. If you've been following this channel because you believe someone in media should actually tell you what's happening without selling you a narrative, then hit that subscribe button right now. It's free, it takes 2 seconds, and it's the only way to make sure you never miss a moment like this one. Because moments like this one don't announce themselves. They arrive fast, they land hard, and if you're not paying attention, you'll spend the next decade wondering why everything changed and nobody told you. Now, let's go back to the beginning, because this ruling didn't come out of nowhere. To understand why a 7-2 emergency order from the highest court in the land is being described inside the Department of Justice as a legal earthquake, you need to understand the game that's been played in American courts for the better part of the last 2 decades. And when I say game, I mean exactly that. A game. A strategic legal maneuver that both political parties have used shamelessly whenever they couldn't get what they wanted through the democratic process. Here's how it worked. A state passes a law, or the federal government issues a rule. And instead of fighting that law through Congress, instead of winning the argument at the ballot box, the opposition runs to a single federal judge. One judge sitting in one district, sometimes hand-picked for their ideological leanings, and asks that judge to issue what's called a nationwide injunction. A blanket freeze. A judicial stop sign that doesn't just protect the people who filed the lawsuit. It blocks the law for every single American, in every single state, all at once. One judge, one ruling. 330 million people affected. Does that sound like the constitutional system your civics teacher described to you? Because it shouldn't. Because it isn't. This practice exploded under the Obama administration, when Republican states started using it to block federal regulations. Then it exploded again under the Trump years, when Democratic states used it to freeze immigration orders. And then again, and again, and again, until the federal judiciary became less a system of justice and more an extension of political warfare. A place where whichever side moved fastest to the most sympathetic courtroom could effectively govern by injunction. And for years, the Supreme Court watched this happen. They signaled discomfort. They dropped hints and opinions. They sent warning shots. But the lower courts kept doing it because the political incentives to do it were just too powerful. States wanted these tools. Federal agencies wanted these tools. Political parties needed these tools. And so the abuse continued, metastasizing through the legal system like a cancer that everyone could see but nobody wanted to cut out. Until now, until this 7-2 emergency ruling came down and the Supreme Court finally said, enough. What the court said in this ruling is both simple and seismic. Federal judges do not have the authority to issue sweeping, universal injunctions that freeze entire state laws for the whole country, when the legal dispute only involves specific plaintiffs. Read that sentence again slowly. because every word matters. If you sue because a law harms you, a court can protect you. But that court cannot reach out and protect every American everywhere just because it has the power to do so, and it feels like the right thing to do. That's not justice. That's judicial legislation. And the Supreme Court, in a 7-2 vote that crossed ideological lines in ways that should make everyone sit up and pay attention, just said, it's over. The era of one federal judge being able to effectively govern the entire nation from a single courtroom in a single city, that era is being shut down. And if you think that doesn't have consequences that reach all the way down to your kitchen table, keep listening, because we are just getting started. This ruling didn't happen in a vacuum. It builds directly on what the court said earlier in Labrador versus Poe, a case that already put the brakes on universal injunctions. But what makes this July 2026 emergency order different? What makes it more significant than anything that came before it is that the court didn't wait for a full case to wind through the appellate system over months and years. They issued this as an emergency order, and that tells you something critical about how the justices viewed what was happening in the lower courts. They saw it as urgent. They saw it as out of control. They didn't have the luxury of patience, because while they waited, federal judges across the country were continuing to issue these sweeping national blocks, freezing state laws, overriding the will of state legislatures, and substituting their own judgment for the judgment of elected representatives. The Supreme Court looked at that and said this cannot wait, and that urgency should register with every American who cares about what this country actually is versus what it's supposed to be. Now, the specific language inside this ruling matters, and I want to walk you through it because the details are where the real story lives. Justice Gorsuch, writing a concurring opinion, used a phrase that I think is going to echo through American legal history for years to come. He called these judges issuing nationwide injunctions mini-legislators. Think about that. Mini-legislators. Unelected, unaccountable, serving lifetime appointments, making decisions that affect every American without going through Congress, without being subjected to public debate, without any democratic check on their power whatsoever. Gorsuch said courts must return to the traditional limits of equitable relief and stop acting like mini-legislators. And when a Supreme Court justice uses language that direct, that pointed, that deliberately confrontational, he is not speaking to the lawyers in the room. He is sending a message to every federal judge in this country. He is drawing a line in the sand. And that line says, you are a judge, not a policymaker. And it's time you remembered the difference. The dissent, written by Justice Sotomayor and joined by the two other dissenting justices, raised concerns that shouldn't be dismissed because they reflect real tensions this ruling creates. Sotomayor warned that restricting nationwide injunctions could lead to unequal and chaotic enforcement across the country, a situation where the same federal law might be enforced in Iowa but blocked in California, where legal rights depend not on what the Constitution says, but on which state you happen to live in. And look, that's a legitimate concern. It deserves to be taken seriously. But here's the counter-argument that the majority found more compelling, and honestly, I think they were right to find it more compelling. The chaos of unequal enforcement is still less dangerous than the chaos of one judge governing 300 million people, because at least unequal enforcement leaves room for the democratic process to eventually resolve the conflict. Universal injunctions don't leave room for anything. They slam the door on every other option and declare the argument over before it's even really begun. The majority chose the messier, but more constitutionally honest path, and I think history will vindicate that choice. Before we go further, I want to stop and ask you something. Are you getting this kind of breakdown anywhere else? Are you seeing other outlets explain not just what happened, but why it matters, what the language inside the ruling actually means, and what it's going to do to your life in the coming years? If not, then you already know what to do. Subscribe right now. Leave a comment below telling me what you think about this ruling, whether you think the Supreme Court got it right or whether Sotomayor's concerns keep you up at night. This conversation matters, and your voice is part of it. The algorithm rewards engagement, and engagement is how we make sure this content reaches the people who need it most. The people who are tired of being talked down to and just want someone to tell them the truth. Now let's talk about the political shockwave, because the legal analysis is only half the story. The other half is what happened the moment this ruling landed, and what happened was immediate, intense, and telling. The White House and the Department of Justice put out carefully worded statements saying they were reviewing the court's order. And I want to translate that for you, because Washington speak is its own language, and most people don't have the dictionary. Reviewing the order means, we got hit, we know we got hit, we're not ready to admit how badly we got hit, and we're buying time while our lawyers figure out how to limit the damage. That's what reviewing means at 11 o'clock at night after a 7-2 emergency ruling from the Supreme Court. It means scrambling. It means damage control. It means that the people inside the DOJ who have spent years using nationwide injunctions as a primary enforcement tool just watched that tool get significantly diminished in a single ruling, and they don't yet know how to operate without it. Meanwhile, on the other side of this divide, state attorneys general were moving faster than the ink had dried on the ruling. Multiple states immediately filed supplemental briefs in ongoing cases, citing this new Supreme Court precedent as direct support for their positions against federal overreach. Some of those briefs were filed within hours. That tells you these state legal teams were ready. They'd been watching the court, anticipating this move, and they had their arguments loaded and ready to deploy the moment the ruling gave them the ammunition they needed. And the argument they're making in those briefs is stark and aggressive. They are saying that the Supreme Court has reaffirmed that states retain the right to defend their sovereignty without being subjected to blanket injunctions from unelected judges. That is a direct challenge to the entire framework of federal enforcement strategy that has defined Washington's relationship with the states for the better part of the last 30 years. This isn't just a legal filing. This is a declaration of intent. The states are telling the federal government, the rules just changed. Keep up. And here's what makes this moment so genuinely significant. As we sit here in July of 2026, this ruling doesn't exist in isolation. It lands in the middle of an already fractured relationship between the federal government and numerous states across the country on issues that couldn't be more consequential or more contested. Immigration enforcement, gun regulations, election oversight, environmental rules, public health policy. Every single one of these fights, every single one, has at some point in recent years involved a federal judge issuing a sweeping nationwide injunction to freeze a state law or a federal rule. Every single one of those cases now has to be reconsidered through the lens of this new Supreme Court standard. And that means the legal landscape across all of those fights just shifted simultaneously. The federal government's playbook in all of those arenas just got a major chapter torn out, and the states' playbooks just got a major chapter added in. That's not a small adjustment. That's a systemic realignment. Let me get specific, because specificity is where this gets real for ordinary Americans. Let's talk about immigration first, because it's been the flashpoint that defines the federal-state power struggle more than almost any other issue in recent years. Under the previous framework, when a state passed aggressive immigration enforcement legislation, the federal government could race to a friendly federal court and get a nationwide injunction, freezing that law before it ever took effect. That's happened repeatedly. It's happened so many times that state legislators in some states essentially assumed their immigration bills would be blocked before they had any real effect. Under this new ruling, that strategy becomes dramatically more difficult. The federal government would need to pursue relief that's narrowly tailored to specific plaintiffs, not a blanket freeze on the entire law. That means state immigration laws, even controversial ones, now have a far better chance of actually taking effect while the litigation plays out. That's a direct, tangible shift in who controls immigration enforcement on the ground. Now take gun regulations. Several states have passed significant gun legislation in recent years, only to have it frozen by federal injunctions. Other states have passed laws expanding gun rights in ways that the federal government has sought to limit. This new ruling affects both scenarios. It doesn't take a political side. It takes a structural side. It says that neither the federal government's desire to expand gun restrictions nor its desire to roll back state-level gun protections can be served through the blunt instrument of a nationwide injunction. The fight has to be more targeted, more focused, more legally precise, which means, practically speaking, that the fights will be longer, messier, and more expensive. But they'll also be more honest because they'll actually have to litigate the specific legal questions at stake, rather than just racing for a judge willing to hit the pause button on an entire state policy. And then there's elections. The issue that sits at the absolute center of American political anxiety right now, in 2026, as we are barely past the midterms and already watching the presidential cycle begin to take shape. The use of federal injunctions to block or modify state election laws has been one of the most contentious legal battlegrounds of the last decade. States have passed laws changing voter ID requirements, early voting windows, mail ballot rules, and more. Those laws have been challenged, blocked, unfrozen, reblocked, and appealed in a dizzying legal carousel that leaves ordinary voters genuinely confused about what the rules are supposed to be. This ruling doesn't resolve those underlying policy fights. But it does say that the tool of the universal injunction, the tool that could freeze an entire state election law for the whole country based on one lawsuit in one district, is now severely limited. And for people who believe in the rule of law, in clear rules applied consistently, in democratic processes that actually function, that's a significant development, regardless of where you stand politically. Because here's the deeper truth underneath all of this. And it's the truth that neither party wants to fully acknowledge. Both Democrats and Republicans have been addicted to judicial shortcuts. When Republicans couldn't stop the Affordable Care Act through Congress, they went to court and tried to get it blocked by injunction. When Democrats couldn't stop Trump-era immigration orders through Congress, they went to court and got them frozen by injunction. When states wanted to implement new gun laws without waiting for the political process to play out, they relied on injunctions. When other states wanted to enforce immigration restrictions without winning the federal policy debate, they relied on injunctions. This has been a bipartisan corruption of the legal system, a bipartisan agreement to use courts as a substitute for the hard, messy, democratic work of actually persuading your fellow citizens and winning elections. The Supreme Court just said that agreement is over, and both sides are going to have to adjust. Neither side gets to keep the shortcuts. That's what a 7-2 majority means. That's what it looks like when the court steps across partisan lines to deliver a structural correction to the system. What happens next is the question everyone is asking. And the honest answer is, it's complicated, and it's going to take time. Because this was an emergency order, not a full opinion, with complete legal reasoning worked out through oral arguments and extensive deliberation. There are still questions about how broadly it applies and how lower courts will interpret it in specific cases. The federal government will look for exceptions. They'll argue that certain situations, national security, perhaps, or public health emergencies, require the kind of broad, nationwide relief that this ruling restricts. And some lower court judges will test the limits of this new standard, pushing back to see how far they can still go before the Supreme Court intervenes again. That's the nature of constitutional law. It's never a single clean resolution. It's a continuous argument about where the lines are drawn and who has the authority to draw them. But the direction is clear. The Supreme Court has been building toward this moment for years, issuing opinion after opinion that pushed back against judicial overreach, that reasserted the separation of powers, that demanded courts return to their constitutional lane, rather than expanding into the policy-making territory that belongs to elected legislatures. This 7-2 emergency ruling is the clearest, strongest, most urgent expression yet of that trajectory. It is the court saying in unmistakable terms that the constitutional correction is underway and it will not be reversed by lower court resistance or by political pressure from either party or by the sheer momentum of decades of legal habit. The court is drawing the line. And the line is this: judges adjudicate disputes between specific parties. They do not govern nations. They do not make policy. They do not substitute their judgment for the democratic will of the American people, expressed through elected representatives. And if you've spent time in a courthouse or studied American legal history, you know that this principle, this fundamental principle about what courts are actually for, has been under serious strain for a long time. This ruling is an attempt to restore it. So where does that leave us? Sitting here on July 20th, 2026, trying to understand what this moment actually means. It leaves us at a genuine crossroads in the relationship between the American people, their elected representatives, their state governments, and the federal power structure that shapes their daily lives. The question this ruling ultimately forces us to confront is a question about democracy itself. Do you believe that sweeping national policy should be determined by one federal judge responding to one lawsuit from one set of plaintiffs? Or do you believe that if you want to change the rules that govern 330 million people, you should have to win that argument in the democratic arena? Through Congress, through elections, through the political process that the Constitution actually established. Because that's the choice this ruling is pushing America toward. Not a choice between left and right. Not a choice between liberal and conservative. A choice between the rule of law and the rule of convenience. A choice between constitutional integrity and judicial shortcut. A choice between the hard work of democracy and the easy path of getting a sympathetic judge to do your political work for you. The Supreme Court, in a 7-2 vote that brought together justices of genuinely different ideological commitments, just said it believes in the first option. It believes that constitutional boundaries matter. It believes that the separation of powers isn't a technicality for law review articles. It's the architecture of a free country. And it believes that when that architecture gets distorted by years of abuse and expedient shortcuts, the court has both the authority and the obligation to step in and correct it. Whether you agree with the specific ruling, whether you share Sotomayor's concerns about unequal enforcement, or Gorsuch's conviction about mini-legislators, this moment deserves your attention. It deserves more than a headline and a hot take. It deserves exactly the kind of deep, sustained engagement that you've been giving it by watching this far. Because here's the bottom line. The ripple effects of this decision will be felt in immigration courts, and gun cases, and election lawsuits, and environmental disputes, and public health regulations for years, maybe decades to come. Law schools will teach it. Federal judges will wrestle with it. Political strategists will have to redesign their entire litigation approach around it. And ordinary Americans, the people who actually live under the laws that get passed and blocked and frozen and enforced and challenged in these courtrooms. Ordinary Americans will feel the consequences in ways they may not even recognize as connected to a Supreme Court ruling from July 2026. That's how constitutional moments work. They don't always announce themselves dramatically in the moment. Sometimes their full weight only becomes clear years later, when you look back and realize that a decision made on a particular day changed the direction of everything that came after. This is one of those decisions. I am certain of it, and you deserve to know about it, understand it, and have opinions about it that are grounded in what the court actually said and why it actually matters, not in the filtered, simplified, politically packaged version that most of the media is going to hand you. This is what accountability journalism looks like. This is what it means to take the American public seriously enough to tell them the full, complicated, consequential truth. If this is the kind of reporting you want to see more of, unfiltered, unafraid, built on depth rather than speed, and truth rather than clicks, then subscribe right now. Drop a comment below. Tell me whether you think this ruling is a long overdue correction or a dangerous restriction on the tools courts need to protect civil rights. Share this with someone who's been paying attention to the power struggle between Washington and the states, because this ruling is the story they've been waiting for. The conversation doesn't end here. It's just getting started. And I'll be here every time the next shoe drops, every time another ruling or another filing or another political move changes the landscape, calling it exactly as I see it. No agenda, no spin, just the truth.